Hello, good morning, everyone. Welcome to this special session of the International Seminar on Family Law and Evidence. We're going to be talking about the empirical twist on these topics of family law. And to discuss this, we have Clare Huntington joining us. She is a professor from the Fordham University. And before she went to Fordham in 2011, Professor Huntington was an associate professor from the University of Colorado. She's an expert in family law and the intersection between law and also poverty law. She has received several awards. She was Professor of the Year in May 2021, and she has been an advisor in the Supreme Court of Justice with Professors Breyer, with Justice Breyer, and also with Judge Merrick. It is a pleasure to have her with us in this session. She has a paper which is really useful to open this discussion here in Mexico. We have been talking throughout the seminar on different topics about evidence and family law, and I think that this is like a wonderful document to open the discussion here in Mexico. So, well, without any further ado, I just want to say that I'm really excited to have Clare with us. I want to welcome her. And as we said, we are going to be having a presentation, and then I remind the audience that we'll be receiving your questions through Zoom, Facebook, YouTube, and we will be discussing them by the end of the session. Thank you once again for joining us, everyone in the audience. And now we can start the conversation with Clare. Thank you.
Wonderful. Thank you so much for having me. I really am just delighted to be here and to join all of you. You know, the miracle of Zoom, to be able to talk to you. I'm actually in New Hampshire in the northeast part of the United States right now. And I'm just thrilled to be able to talk to you today. I'm going to talk for a while and present some thoughts about this, but I also very much want to hear your questions and concerns, and I look forward to the conversation that we'll have towards the end of this session. So let me share my screen because I have a PowerPoint that I've put together just to help guide us through this a little bit. Let me just get myself set up here. Okay, so I want to actually, before we start, I want to tell you how I got into this project, which is in 2015, I started writing a paper about what we call in the United States non-marital families. So these are families where the parents are not married when the child is born. And for most of these families, some of them will get married, but most of them don't get married. So they stay unmarried and usually typically break up at some point within the child's first few years of life. And these non-marital families, there's been an enormous increase. Now in the United States, about 40% of all children are born to unmarried parents. And I really felt like family law scholars weren't sort of tackling this enough, weren't trying to understand what are the challenges that are facing non-marital families, and what are the ways in which the basic thesis of my paper was that family law is really for marital families. It's, and I won't talk too much about it because I know that that's not the topic for today. It's about marital families rather than non-marital families, and it wasn't designed well for them. But as I was going around and presenting this paper, I kept hearing again and again, well, sorry, but back up for 1 minute. One of the findings of the paper was that for unmarried parents, when their relationship ends, the mother often acts as an informal gatekeeper to the child, and she will only let the father see the child if she wants, you know, sometimes for good reasons, right? She could keep the father away if there's a history of violence and whatnot, but other times it's for reasons that are not, you know, for different kinds of reasons. For example, if she's in a new relationship and her new partner is jealous of the father, so then she would keep the father away from the child. And so one of the things I was arguing for was that these unmarried fathers should have greater access and be able to see their children. And again, I kept getting the question, which is, well, is that good for the kids? Like, is it going to be good for children to have this relationship with their fathers? And there's interesting evidence out there, that we can talk through. But I was just so struck by how that was the entire conversation was, is this good for the kids? As opposed to thinking about sort of this very fact-based, outcome-driven, are children going to benefit if they have a relationship with their father? As opposed to a more holistic inquiry that might say, well, what are the rights of a father to be able to see his child? What are the rights of the child to be able to see the father? What might be some things that we can't measure, but that might be still really important about protecting the father-child relationship? And so what struck me was that I think it's important for us to look at the evidence about relationships between unmarried fathers and their children, but there's a lot more at stake too. But I was so struck that people didn't want to have the larger conversation. They were just very focused on this outcome data. So that's what led me to want to look more broadly at what is the role of empirical evidence in family law. And that led to this project today. I want to say at the outset, because whenever I present this paper, I always get the question, how come you don't like evidence? What's wrong with empirical evidence? That is not what I'm saying. I think empirical evidence is critical. I couldn't do my work without it. I think it plays a foundational role in any system of legal regulation. It helps us understand a problem. It helps us understand effective solutions and whatnot. I'll go into that more, but I just want to say up front, I am a huge advocate of the use of empirical evidence. But to my mind, we weren't having a balanced conversation about it and talking about what were some of the downsides as well. So in this presentation, I'll probably talk a bit more about the downsides, but I really just want to say up front that I really do think it's essential. We have to have empirical evidence. I have one more introductory comment before I start going through my my slides, and that is, what do I mean by empirical evidence? And so what does that I mean? I mean that in a very broad sense, so we can think about quantitative evidence, statistical evidence that shows, for example, I just cited a statistic, 40% of children in the United States are born to unmarried parents. That's empirical evidence, right? That's quantitative evidence that describes the world. There's also a lot of qualitative empirical work, which I think is equally important, often done by sociologists or other social scientists who look at, sort of describe in a more anthropological way, how do families work? So for example, in the United States, there's a really wonderful sociologist named Catherine Eaton, who has worked with two different co-authors and has done important fine-grained work looking at communities of where non-marital families are very prevalent, and helping us understand through specific stories of actual people, obviously changing their names to protect their privacy, but telling the stories of actual people to understand, okay, how do a couple come to have a child without getting married? What are their reasons for doing that? What are the challenges they face? Why might they stay together? Why might they break up? So both quantitative empirical evidence is what I'm talking about, and also this qualitative empirical evidence. So really, it's anything that helps us describe the world. Okay, so just jumping into this now. I want to start with the idea that empirical evidence is all around us. So you may know this movie. This is Moneyball, starring Brad Pitt. And this is one of, certainly in the United States, one of the most popular ways that we've come to understand the prevalence of empirical evidence. So the basic idea was that this team, the Oakland A's out of California, didn't have a lot of money, but then they wanted to be able to win more baseball games. And so they brought in a statistician, someone who really knew a lot about statistics, and they used a statistics-driven approach to putting together a team, and they ended up winning the World Series for several different years. So it's a really fun movie to watch, but it's also just indicative of this broader trend. So let me just talk about sort of where, again, this may be quite US centric because my paper is US centric. So those are where my examples are coming from. I want to hear from you about where you see this in Mexico. So when we talk about the rise of empirical evidence, I associate it certainly with, this is a former mayor of New York City, Michael Bloomberg, whose whole approach, he came from the private sector, and his whole approach to governing was about evidence. For better or worse, we could talk about this. He actually got this, one of his big policies ended up being was found unconstitutional. It was this policy called stop and frisk, which was pulling over young men, statistically much more likely to be Black and brown young men, to search them to see if they had weapons on them. So that was a not good use of empirical approach to governance. But he had lots of ways in which he did embrace empirical evidence to try to more effectively deliver government services. So that's associated with Bloomberg. More generally, you don't worry about the Venn diagram too much, but it's just to show you this is something called evidence-based medicine, which is very much, a drive in medicine. I mean, medicine is, would hope for a long time now, been evidence-based, the idea that we do studies about what's effective, what drugs work, what surgeries work, those kinds of things. But the idea of calling it evidence-based medicine is somewhat more recent, and is very, very prevalent in the field. And sorry, I went the wrong way. And then Obama was absolutely associated, his administration was associated with this idea that government should be making decisions based on evidence. Oh, but where do we see this in family law? So that's sort of where we see it more broadly in the culture and in the government. Where do we see it in family law? Well, the first point is we actually originally don't see it. So in the United States, traditional family law is very much based on this idea of a nuclear family, a mother, a father with biological children. And there are real protections for these families. So this is, we have this basic principle, which is rooted in our Constitution, of family autonomy. And the idea is that parents in a nuclear family should be able to make decisions for their children without too much interference from the government. Or at least if the government is going to impose, sort of make decisions for parents, it has to have a very good reason for doing so. For example, requiring education, banning child labor, those kinds of things. But in general, we let parents make a lot of decisions for their children. And this is rooted in these two cases from the 1920s, Meyer versus Nebraska and Pierce versus Society of Sisters. These were both cases about educational decisions that parents were making. One was about teaching a foreign language, teaching German in the school, and the other one was about where a child could go to school, whether the government could require a child to go to a public school rather than, in this case, a parochial school, Catholic school. And in both instances, the US Supreme Court said, no, these are decisions for parents. Parents get to make these decisions. And without citing any evidence, it basically just said, parents know best what is for their children. This is very much this idea of we just have this intuition that parents know what they should, what's right for their children, and the government should defer to that. Another big, so we have this family autonomy, and that parents, and then the others. Sorry, tripping over my words. The other assumption was that parents are going to make good decisions for their children. So there was another famous case called Parham versus JR. And this was a case where parents were committing their child to a hospital for people with mental illness, for young people with mental illness. And the question was, should the parent be able to make that decision, or should the child be able to have their own lawyer, and that lawyer be able to represent the child, right? Because maybe the parents wanted the child to be in the hospital for people with mental health challenges, but maybe the child didn't want that. And the Supreme Court said, no, this was a quote from the court where it says, pages of human history, pages of human experience teach that parents act out of the best interest of their child and will make decisions that are in the child's best interests. So we just assume that this is true. Moving on, there are other ways in which, again, we make these assumptions about, we just have this intuition rather than looking to evidence. So for example, for us, we have these testimonial privileges for spouses. So in a criminal trial, if one spouse is on trial for a crime, the other spouse can't be forced to testify against, right? So let's say one spouse is accused of murder and the other spouse happens to witness the murder. They can't force the non-defendant spouse to come into court and say what they saw. And then similarly, there's a protection that applies also in civil contexts, which is if spouses, again, this is only for married couples, but spouses have a confidential conversation between them, they can't be forced to reveal that. So this is called the marital communications privilege. And both of these, when the courts were recognizing these privileges, they just, again, made assumptions about intuition about why we need these. They said that, this is going to promote marital harmony, and that if you force spouses to testify against each other, this would harm the marriage. That may well be true. I'm not contesting the insight, but rather trying to point out that courts felt no need to cite to evidence for this. And then, unfortunately, sometimes when courts did, or government policies were based on evidence, they were based on junk science, and really regrettable. And junk science is a nice term for what we might really just call, in this context that I'm going to explain, but really just pure racism. So, for example, in North Carolina, one of our states in the United States, there was a sterilization program that went after low-income women, and particularly low-income women of color, Black women, and between 1929 and all the way up through 1975, more than 7,000 women, 7,600 women were sterilized in this program. And the way that they justified it was this thing called phrenology, which is a terrible, deeply racist, and absolutely no basis in science whatsoever, which is to say that races have, so here's it's comparing North African, European, and African cranium size, the size of the head, and saying that that is then related to intelligence. And it's again a racist ideology that was then used to justify why Black women, and especially low-income Black women, shouldn't be allowed to have more children. So the bottom line is, generally courts and the government didn't invoke evidence, they just relied on intuition, or when they did invoke evidence, it was this, certainly in this circumstance, really racist evidence, or just wasn't reliable science. Okay, so when does this start to change? One of the big changes, again, focusing on family law, is in 1960s. In the 1960s, there was someone named Henry Kemp, and he was a pediatrician working out of Colorado, and he started seeing children in his practice who had unusual injuries, and injuries that couldn't be explained by, falling off a climbing structure. These were kids, there's, as many of you know, I'm sure if you work in the area of child abuse, certain kinds of fractures to a child's limbs that really are much more likely to be the result of physical abuse by a caregiver, rather than an accident, like a child falling off a bed or something like that. And so he started looking at this and identified this pattern and called it the battered child syndrome. And this gave rise to the entire modern child welfare state, or what we now often call the family regulation system here in the United States. So this is the system that we have that's both criminal and civil for protecting children who are or at least the allegations are, or the concerns are, that they've been abused or neglected by their parents. But this was very much in this early science, in this early work and studies that were done by Henry Kemp. Okay, another we'll sort of fast forward, marriage equality. So in the United States, really began in 1996 with a decision, 1994, I think it was, maybe it's 1995, sorry, getting the exact year wrong, in Hawaii, but that was never really took effect. So really it began in 2003 when the Massachusetts state Supreme Court recognized a right to marry for same-sex couples in that state. And then between 2003 all the way up to 2015, with the decision in Obergefell, when the US Supreme Court recognized right to same-sex for same-sex couples to marry, rooted in the U.S. Constitution. So over this 12-year period in the United States, we had a enormous ongoing conversation that was happening in state legislatures, happening through citizen ballot initiatives, and especially happening in courts around marriage equality. But what I really want to emphasize here is, especially in the courts, this was very much driven by empirical evidence. There's a wonderful book by Kenji Yoshino, who is a law professor at NYU Law School, who has written about this. So if you want to read more, that's a great resource. But I'll just tell you briefly, this was especially some of the cases that went to the Supreme Court turned on two trials that were happening, one in Michigan and one in California. And the trial court judges in those cases brought in all kinds of experts to talk about what is the impact, especially on children, of not having their parents' relationship recognized. And then also, because some of the allegations were that children are harmed if they're raised by same-sex parents, really looking closely at whether there was any evidence showing that children are harmed. There is no evidence whatsoever that children are harmed by having same-sex parents. Children are harmed in all kinds of ways by parents who are neglectful or abusive, but that's not correlated with the sexual orientation of the parents. And so this evidence very clearly found that children were going to be absolutely fine, and that there was real harm to both the children and the parents for not having access to marriage. And so this really laid the foundation for marriage equality, right? It's hard to imagine the US Supreme Court in 2015 deciding that there was a constitutional right to marry someone of the same sex, if in fact there was a lot of evidence out there showing that it had some harms, right? But because there wasn't that evidence, I think that made it much more easy for the Supreme Court to say that the Constitution did protect that. Okay, so that's one of the big areas where we see the use of empirical evidence. Another area in litigation, and this is much more controversial, and again, more in the potential column of junk science, there's a lot of showing that this is not reliable science, something called parental alienation syndrome. So this is when parents are getting divorced or separated, and one parent tries to turn the child against the other parent. So certainly there's anecdotal evidence, as many of you who practice in this area know, not all divorcing parents help support a relationship between the child and the other parent. That's not controversial. I think that's widely accepted. But the question is whether or not this is a syndrome, right? So this was someone named Richard Gardner, who really, without following all the basic scientific protocols, came up with something called parental alienation syndrome. It had these different, characteristics, and convinced the courts that this was a huge problem and that they needed to take action, and particularly punish. I don't mean punish in a literal sense, but that they had to try to protect the child's relationship with the parent who was being alienated. Now, there's a lot of work that's been done in this area. I'm not going to go into right now, but that shows, I do cite this in the paper, that shows how this has particularly been used to harm women, and often harm to use women who are claiming that their former partners were abusive to them. So this is a significant problem in the United States. So this is a way in which, I'm going to use science in quotation marks because it really is not reliable science, but in which empirical evidence has been introduced, but without a rigorous study to show whether or not it was reliable, and has ended up influencing litigation. Okay, so other ways in which empirical evidence is used in legislation. So intimate partner violence, right, we also call domestic violence, is an enormous problem, I think, really all around the world, and certainly in the United States as well. And when either local governments or state governments, and then the federal government plays some role, particularly in providing funding, but in other ways as well, when they seek to address intimate partner violence, it's often drawing on empirical evidence, right, about what is helpful. But this is where it can get a little murky. Well, actually, I guess I'll save this for a moment where I talk about what are some of the downsides about using empirical evidence in this intimate partner violence context. But I use it to here just to say that it really did play a role, especially in many states states and local governments adopting two policies that are very widespread in the United States. Mandatory arrest, which is that if the police come to a home and find that there's been evidence of intimate partner violence, they're required to make an arrest. They're supposed to arrest the primary aggressor, but if it's not clear who the primary aggressor is, they end up arresting both people or more than two people. So that the mandatory arrest. And then another policy called no drop prosecution, which is that if the survivor of domestic violence doesn't want to go forward with the prosecution, the prosecutor still does it, still proceeds, and then treats the survivor as an adverse witness and calls them in. So both of these were attempts to get around the problem of the police not taking intimate partner violence seriously and just telling the abuser to walk around the block and the police would go home, or prosecutors not following through on cases. But as I'll talk about in a minute, it can be more complicated than that. So again, the point here is that empirical evidence is widespread. And then my final example of it being used is in back to the child welfare system or the family regulation system. The way it's used for the administration of the system. So we now in the United States, many localities are using something called predictive analytics, which looks at a number of different factors in individual cases, and then also can be done on a geographic, looking at a locality to understand whether a child's at risk or what is a risk, sort of the risk score for the child of being abused or neglected. And these are used, the idea is to try to use them to predict, if a call comes in and the child there's some allegation that the child's been abused or neglected, to be able to use this, it's an algorithm to be able to say, well, is this something, are there other characteristics in the family that would make us concerned about this? Okay, so I'll say more about that soon. This is just more examples of what the risk assessment would look like. Okay, so let me again, I'm not going to talk about this a lot, or the benefits of evidence-based family law, but I want to emphasize that these are enormous, and I really am strongly in favor of using empirical evidence in family law. So it's important because it can guide policy, right? We want to know what's effective. We want to know, if we're trying to reduce intimate partner violence, it's helpful to have studies to show that this kind of intervention reduces it, or this kind of intervention doesn't reduce it, right? It can just lead to more effective policy. It can also helpfully guide state investments. There's always going to be limited public money available for something, and we want to make sure that we're using that money cost effectively. So just to give one example I've written about a lot is the importance of early childhood development and the need to invest in children. And so in the United States, our major investment in children, well, let's just focus on education for a minute, doesn't start till the child begins school at age 5 when they go into kindergarten. But there's so much evidence that preschool, beginning at age 3 and 4, plays an enormous role in helping children succeed once that they get to school. Because the problem is, once children arrive in kindergarten, there's already a big, what we call achievement gap between, it's very much connected with income, between low-income children and middle and upper-income children. And that has already been put in place in those first few years of life. But there's great evidence showing that if we invest in high quality preschool for ages 3 and 4, that has these enormous benefits going down the road. And it's much more cost effective to invest in preschool than in a job training program for someone who hasn't completed high school. So, and here, this is the work of a Nobel Prize winning economist. I mean, many people have done this work, but it's particularly associated with someone named James Heckman out of the University of Chicago, who has really shown this again and again, the cost benefit, the benefits of investing in early childhood. So that's a wonderful use of empirical evidence that helps us use government dollars wisely and to effective ends. It can also help unmask prejudice, right? So again, back to the marriage equality litigation, when people were just making these claims of like, oh, it's going to harm the children to be raised by same-sex parents. Okay, well, let's put that to the test and let's see what the evidence shows. And the evidence didn't show that, right? There really was nothing. And so it really was much then easier to see that's much more rooted in homophobia rather than a real concern for children. So that's just one example of the way in which it can help unmask prejudice. Another example, actually, coming back to the unmarried parents in the United States, often we have this phrase that we use a lot called deadbeat dads. These are fathers who aren't involved in their children's lives and don't pay child support. And because of the ongoing racism in this country, that idea of a deadbeat dad is often associated with Black fathers. But in fact, the evidence shows that among unmarried parents, Black fathers are much more involved with their children than white fathers are, right? So again, this evidence can help us understand the ways in which stereotypes are making, people are acting on stereotypes rather than real evidence. Okay, and then finally, I'm only cautiously optimistic about this. You know, that evidence, empirical evidence, can sort of counterweight politics. I think certainly, you know, in the United States, COVID has become so politicized. You know, despite the evidence, let's just go with say vaccines. You know, there's overwhelming evidence that vaccines are effective in preventing serious illness and death, and that they present very, very limited risk. And yet there's a real resistance to vaccines. So, and it's become politicized. So I don't want to say that this is like, oh, if you just tell people, here's the evidence, then they change their minds and they, you know, they'll give up either their prejudice or you know, political beliefs, whatever it is. It's not as simple as that, but at least it is some counterweight. It's some ability to provide additional information. Okay. So what are some of the concerns then? So this is where I'm going to spend just a little bit more time. So I want to start with two concerns. One is data reliability, right? So this is always true about empirical evidence, which is, you know, are the data reliable? Is this something that we can, you know, were the studies done well? When I was telling you about the parental alienation syndrome, that's a great example of studies not done well, and that frankly weren't submitted and subjected to the scientific method, and yet still did have an influence. Another example, this is not so much about, well, this is about sometimes data, it's not just that it's unreliable, but it can be incomplete. So I don't know if you have followed this evidence, but a big thing going on in the United States are these things called ACEs. That's the ACE study, which is the Adverse Childhood Experience, ACE study. And this is really fascinating research that was originally done. It was originally done through Kaiser, which is a private healthcare, nonprofit healthcare organization. And the doctors were looking at which obese parent, looking at obesity and trying to understand what led to obesity and what, and what didn't. And so they started doing these surveys of their patients and asking really simple questions. So it's just a short number of basic questions, asking about what we now call adverse childhood experiences, things like, were you abused as a child? Did you have a parent who was incarcerated as a child? Did you grow up in poverty? Very specific things about the child's life within their family. And what they found was that there was a very, very strong correlation and really a kind of a linear correlation between the number of adverse childhood experiences, right? So the number of yes answers to these questions and health outcomes, far beyond obesity. Actually, one of the strongest ones was also connected to heart attacks. But for a whole range of illnesses, the more adverse experiences the child had, the greater risk they had for these poor outcomes as an adult. And it wasn't just lots and lots of evidence and conversation about this that I'm just going to give short shrift to. But it wasn't just, for example, that a child who, let's say, had been abused as a child then was maybe more likely to engage with, substance abuse and whatnot as an adult, and that was the problem. It wasn't even controlling for behaviors like smoking and alcohol and whatnot. There still was this correlation. So a very strong correlation that's been quite useful. It's been really transformative in the United States. This is when we talk about the buzzword often that's used now is trauma-informed policies, interventions. This is really what they're talking about. They're saying, let's understand. The phrase that's often used is, rather than asking what's wrong with you, we ask what happened to you, so that we can understand someone who might, as an adult, be presenting with a range of physical or mental health challenges. And again, rather than saying, what's wrong with you, we say, what happened to you? Help us understand what might have happened as a child and how that's informing your results. So all of that is, there's some downsides to it as well, which I'm happy to talk about in the Q&A, but it's useful, and it certainly helps guide policy on a broad level. But my point is, the original study was done on a middle-class population that was overwhelmingly white. And so they didn't look at what are some other factors that might also have an impact. What are other adverse childhood experiences beyond just what happens in the family? So when researchers started looking more broadly, and particularly looking at, because one of the factors is, did you grow up in a family where there was domestic violence among the adults? So that has a strong correlation. But rather than just looking at the family, they started looking more broadly at is the child exposed to community violence, right? Do they live in an unsafe neighborhood? Do they not have access to resources? Are they subject to discrimination? And what they found was, when you look more broadly at these adverse experiences, which are much more likely to face low-income children and children of color, those too have an impact. So my point here is, again, not so much about data reliability, but more about the incompleteness. What we only have information on what we study, and we need to make sure that we're studying more. Okay, and then and then the other thing I'd say about data reliability, or the sort of this is like the ACE about what's missing, is what do we ask about, right? So let's come back to my example that I started with about non-marital fathers, which is the studies, saying like, well, does it benefit children to have relationships with their fathers? They would look at things like, what's the high school graduation rate of the children? What are the adult earnings of the children? Those are important. We want people to graduate from high school. We want them to be able to be economically self-sufficient. But we also should ask, what's their sense of belonging and connection to their fathers? Do they feel close to them? What is it, what are these things that may be harder to measure, but are also enormously important in life? And so that's the point about sort of what are we not asking about? Okay, and then, so even if the data is reliable, are legal actors able to translate it, right? So what does it mean to then implement this data? So when we think about, let me go back to my ACE score, it's fine and helpful at a policy, sort of at a policy level, to be able to say, wow, it turns out children who grow up in homes with domestic violence, abuse, a parent who's incarcerated, have these bad outcomes. Let's try to, or it's correlated with worse health outcomes as adults. Let's try to address those problems. That's helpful. But it's much more problematic if we look at an individual child and say, what's your ACE score? Should we remove you from that home? These are the kinds of things that are concerning. Or the example I talked about before, the junk science that was done on the parental alienation syndrome, or the unreliable science that didn't go through the scientific review, and yet courts are relying on it. And so courts don't necessarily have a helpful way to be able to test the science and to know what's reliable. Another good example, I promised I would come back to this, in intimate partner violence. So as I talked about before, there are these mandatory arrest rules that many jurisdictions have adopted. And part of that was based on, part of it was getting to, wanting police officers to take the violence seriously. But part of it was also based on evidence showing that if, this was originally done on male aggressors, so if a man was arrested, he was less likely to commit domestic violence again in the future. So that seems like a good policy then, right? That's a good reason, one good reason to be in favor of a mandatory arrest policy if it's going to reduce recidivism, lead to fewer people recommitting the crime. But what turns out was that original research, it couldn't be replicated with different populations, that it was originally based on more middle and upper income men who were employed. The employment was the most important factor. So for them, they had something to lose. This was shameful to be arrested. Maybe their jobs were at risk, and they were sort of scared enough, or filling in the blanks here. But the idea was it was enough of a deterrent, the idea of being arrested, that they wouldn't then recommit the crime. But when they went to recreate this study with different populations, and particularly with men who weren't employed, there wasn't the correlation between mandatory arrest and reduced recidivism, right? So that's again a way in which we take this evidence, and it's hard to implement it in a nuanced way, either because it's incomplete or it's hard to figure out exactly how to put it into legal policy. Okay, but even if the data were reliable and legal actors could translate it perfectly, there's still concerns. So let me just name a few of them. The first is that it privileges outcomes. Again, I'll return to my unmarried father example, which is it's very much about, are the children going to graduate from high school, rather than is it important to a child? Maybe it is, maybe it isn't, but is it important to a child to have a relationship with the father? Or let's go back to the marriage equality, right? So it was fortunate that the evidence showed that there were no bad outcomes for children raised by same-sex parents. But what if the high school graduation rates had been just a little bit lower, right? Would we have said their parents can't get married? Right? What is that? What do we really want to? There are other things at stake besides specific outcomes. And so the concern about empirical evidence is it focuses all the attention on these outcomes. And then it also really obscures, value-based judgments. There are all kinds of, again, reasons why we make decisions, and we want to make sure that that values are very much still playing a role, whether it's equality or opportunity. These other sometimes more nebulous values, anti-discrimination. We want to make sure that we are still really emphasizing those things. And sometimes the concern about using empirical evidence is that it can mask this, right? It can really be about, so let's say someone doesn't value the relationship between an unmarried parent and their child, unmarried father and the child. They could say, oh, no, this is not about that. I'm not against unmarried fathers. I'm just following the evidence, right? Just going where the evidence takes me. Well, that may not necessarily be true, right? It really may be more about underlying discrimination or value-based judgments. I guess this last one is, is this idea of normalizing discrimination is quite similar, right? It can make it so that we really, again, don't always have a good reason for adopting rules that can discriminate on the basis of, marriage and whatnot, but we still do. And then the final is just the status quo bias, right? Which is that there's often a strong preference in favor of not changing things, and keeping the focus on empirical evidence can really encourage that. I mean, in some ways it can help us change policies, but oftentimes it doesn't. So I'm going to, let me just say a little bit more. Sorry, I realized more I want to say here about where this is, what we should do going into the future. So I really think it's important when we are thinking about empirical evidence to really think separately about values and outcomes. And so here we really want to focus on, yes, there are certain outcomes that we want, but what are also the values that are at stake? And we don't want to lose sight of those. So I just think it's important to elevate, to name that issue and elevate that conversation. So we're very much recognizing both, that both are important and play a role in family law. Secondly, and this I really am curious about what you might have in Mexico, because we don't have anything that works particularly well in the United States, or at least in some contexts we don't. What are the gatekeeping tools for whether it's judges or members of a legislature to be able to say this is good and helpful science and this is reliable evidence and this isn't? So one of the ways we do that in the United States is we have these rules about letting in experts. So what's called the Daubert test is an evidentiary standard in federal courts, but state courts have sort of similar equivalents, which is to be able to say, yes, this expert is qualified in these ways, and therefore allow them to testify as an expert. Of course, the adversarial process is important. So for example, in the marriage equality litigation, there were some researchers who got up and would say, oh, it's really important. One of the big issues was around gender complementarity. You've probably heard this term, the idea that a child needs both a mother and a father. The idea that it's not just two parents, but parents of different sexes is important to the child. So the side that was arguing against marriage equality was saying gender complementarity is important for children. And the experts, they brought forth a couple of experts who would say they had evidence supporting this, and the other side just eviscerated that argument and really showed that there was no basis to it whatsoever, that the studies weren't reliable. And so that adversarial system is one way that we do that in courts, but especially in family courts, which are just overwhelmed with the number of cases that they have to go through. I think we don't always have great ways to help family courts figure out what is useful science and what isn't useful science. And so I could imagine some hopefully nonpartisan panel that might look at different things. So for example, could look at the evidence around parental alienation syndrome and be able to identify its flaws, or just look at other evidence. I mean, other things about what are the benefits of mandatory mediation, those kinds of things, and use that in the family court system. So I think there's more that we can do in the courts, although the courts are not terrible. My concern is somewhat more about the legislatures, which are obviously political bodies, and that we really see that system being co-opted and there's not a great kind of clear way to be able to challenge the evidence that's being introduced. So part of it is different sides, someone who's supporting legislation and someone who's opposing legislation can each bring in evidence. And so, in the United States, we have these hearings and whatnot. And so that's one way, but that assumes that you've got both sides are being represented or allowed to speak, and that then the lawmakers have the wherewithal to be able to distinguish from the different sides. So around abortion, this was a huge issue. I'm sure we're going to see it a lot more now in the wake of the Supreme Court's decision. But even before the decision in Dobbs, state legislatures were passing restrictive legislation, and they would do it based on, so for example, one of the rationales was women come to regret abortions. And so South Dakota was a legislature that adopted a restrictive legislation based on that. And the evidence, in quotes, air quotes, was someone coming in. They clearly had rallied pro-life, anti-abortion advocates to be able to come in and talk about how they regretted their abortion. But really, there's a lot of evidence out there, particularly by the American Psychiatric Association or maybe the American Psychological Association, that shows that no, women don't regret their abortions by and large, right? That's not an individual may, but overwhelmingly women do not regret their abortion. So the South Dakota legislature wasn't looking at the reliable study. They were instead just listening to the anecdotal evidence. So the question is how better to do it in legislatures. And then, of course, as always with this, we need to pay attention to the ways in which the evidence doesn't take account of intersectionality, doesn't take account of what it means in particular to be low income and a person of color, low income and a person of color and non-binary or trans or gay or lesbian. So all the ways in which we need to make sure that our evidence is really taking these very salient categories and experiences, and especially when they intersect, into account. And then I'll just close with this, which is, I think there's a real role for legal scholars here, and there is quite a bit of this in the United States. So, for example, on the parental alienation syndrome, there's a wonderful scholar named Joan Meyer from George Washington Law School, who's done a lot of work challenging the parental alienation syndrome, and then her own empirical studies of looking at how family courts use it, that and then in other contexts as well. And I think that kind of work is really important, that legal scholars are able to, they have the training, they understand the legal system, but have the academic training to be able to look at the research and figure out what's useful and what's not. And with that, I'll just open it up for questions. Shall I close down my slide screen for now?
Yes, you can stop sharing.
Okay, great.
Thank you very much. I think your presentation was so clear. You guided us through the benefits, through the concerns, and I think there's a lot of similarities with the situation in Mexico, and we have received a few questions, and I would like to start with several questions that are related. I'm looking at the questions right now, and we have this context in the family courts where sometimes there aren't enough resources and there's a lot of workload. Can you give us like some pieces of advice? Because people are making this question on how to use gatekeeping and controlling evidence, and answering your question about what's happening in Mexico. I just want to put you into context. We are under the creation of a new code that will be applicable in all the country when it comes to family law. So I think this is a good time for us to establish the rules, because maybe in the legislation rules are not clear when it comes to gatekeeping. And there are a lot of questions about that. Can you give us some advice? What would be like a good training for controlling evidence, or what are the standards that you could suggest? So I don't know, we have some specific cases here, but I guess that this can be applicable in different cases. So in general terms, and taking this context into consideration, all of these difficulties that we are facing in courts, which training could be useful to use reliable evidence? And I would also like to add, how can we detect if there is a consensus on a specific value, or if we are talking about a case where there's no consensus?
Great questions, really, really good questions. So here's what I would say is, I think we always need to have humility around empirical evidence, right? So we need to treat it as useful, but we also need to bring skepticism to it. And so, because like I said, it's, and this is part of the natural scientific process. This is not a sort of a reason to reject empirical evidence. It's just to understand what it does. Most empirical evidence, let's say studies about families, are, here's one study that looked at this issue with this population and sort of helped further our knowledge a little bit. Then someone takes that and tries to replicate it in another context, or tries to build on it. And the idea is that slowly, slowly, we build up knowledge that together can help us understand, understand an issue better. So So the question is sort of who we want to make sure when we're thinking about gatekeepers or people who can advise on this, who understands that, right? Because often I'm sure you'll see this, it'll get reported in the media. There'll be some study that shows like, I don't know, oftentimes in the United States, we get this around health, like eating blueberries will, cure you, make sure you don't get cancer. It's like, actually, the research is a lot more complicated. It's hard to show cause and effect, lots of different factors, and so we need people who are trained in both the physical sciences and the social sciences to be able to, again, translate this. So I do think there is a real role for experts and, again, for academics. And the idea, hopefully, is that academics are more neutral than advocates who are out there, and certainly than politicians. To be able to, to understand these are people who are trained, who oftentimes have PhDs or other kinds of graduate degrees, and understand the limitations of empirical evidence, and also know how to use it, and then ideally how to then translate it for a broader audience. So I do think there's a role for universities to be able to do this. There are some great examples. I'll just give you one. The Harvard Center on the Developing Child is a great example of how Harvard brought together neuroscientists and other child development experts and translated the evidence that we know that, is very technical, very much based in neuroscience, but made it available for the public about sort of what's effective. Now that's, in some ways, it may be too simplified, because it's really at the level of like these 2 and 3 minute videos that are helpful for the public, helpful for legislatures and whatnot. And so what you may want is something that's in between, right? That's a little more sophisticated and nuanced, but still not as highly technical. I can't read a article by a neuroscientist and tell you what the takeaway is. I need someone to help me translate that. So again, I think the universities can be an enormous resource here. I don't know what professional associations there are in Mexico of, let's say, family court judges, but in the United States, we have some important ones. So I'll just talk about 2 important professional organizations. One is the National Council of Juvenile and Family Court Judges, and that's a great resource. And that's the kind of place where they have an annual conference, they have annual newsletters. I think they can and should do more to be translating empirical evidence for the judges, but that structure is already in place. There's also something called the Association of Family and Conciliation Courts, which is another body of family courts. They too have an annual meeting and whatnot. But that is a way, those are both bodies, and especially the AFCC, the Association for the Family and Conciliation Courts, their annual conference is very much lots of experts coming in and presenting the most recent evidence. Now, obviously, not everyone can make it to a conference like that. It can be expensive, but I think there's a lot of material there to be able to be translated. So that's for the courts. The legislatures, I wish I had a better answer. I just don't, because again, I mean, mostly speaking from the US context, it's so politicized. I just don't think there's a lot of trust that evidence that's being introduced, people see it through their political lenses. So I don't know that there's an easy fix for it. But again, I keep coming back to, and I'm sure it's because I'm an academic myself, but I keep coming back to the role of universities in a society of being somewhat more removed, ideally more neutral, a source of knowledge, and really trying to use those institutions to interact more with our public institutions. That universities should more clearly be a resource. And then the second point about the values, I think that's so fascinating. Yes, how do we, it's one thing if there's a consensus about a value, and another thing when there's not. And then how do we allow, when that consensus is changing? I mean, marriage equality in the United States is a great example, which is it went from, in 2003 up until 2003 with a US Supreme Court decision called Lawrence v. Texas, it was permissible to criminalize homosexual sodomy, right? So homosexual sex states were allowed to criminalize that. So that was only prohibited in 2003. And 12 years later, the Supreme Court found a constitutional right to marriage equality. So that's a huge change in public opinion. And there really were, public opinions sort of supporting on both ends, both from, really well-entrenched homophobia going back millennia, certainly, decades and centuries, but up to now marriage equality, not completely being accepted. And I think it's a little bit more in play now, but certainly it is much more accepted than it used to be in the past. And so, my point is not that we'll know in any particular moment that there's a consensus, or I think the way the consensus shifts is complicated and involves relationships between laws and norms. I've written about that separately. But really my point is that we just don't want to lose sight of these values. We need to be having these conversations about contested values.
Yes, and about that, and thinking about the different debates about the abortion, as you said, there seemed to be a consensus. Thinking about the US context right now, there was a consensus, and suddenly this debate emerges again, and the consensus is completely broken.
Yeah, I mean, it's complicated in the US because it's not so clear what the consensus is. I mean, there's fairly strong evidence that a strong majority of Americans want some access to abortion. But when you start drilling down on it, there's more opposition than you might think. It's very regional too. So in the more conservative states, there's more opposition. And also, people may say access to abortion, but that doesn't mean they think you should have it all the way up through the first trimester, or even, 24 weeks was about what used to be protected. But so that many people are like, well, yes, you should have access to abortion, but only up till 6 weeks, which is really so little time. And then also, and this is, again, it's a little bit farther away, but I do just have to mention, which I think a lot of people just simply don't understand what it means. Most people, I'll just say for myself, until I actually had my children, I didn't understand that you start counting the weeks of pregnancy from 2 weeks before you actually even get pregnant, right? It's from the date of your last menstrual period. So when we talk about someone who's 6 weeks pregnant, that can mean it's only a week or two after they've missed a period. It's a very, very brief window for someone who's 6 weeks pregnant. It doesn't mean, I think in the public, in their minds, they think they find out they're pregnant and then they have 6 weeks to get the abortion. That's actually not what these fetal heartbeat, in 6 weeks, well, not the fetal heartbeat, but the 6 week bans are about. So I think it's also a problem if people don't really know what they're being asked or don't always understand it. But yes, I do think there is some fairly strong consensus for some access to abortion, but it's not being played out for all kinds of reasons about it and pathologies in our political system right now.
Okay, thank you for that. And also talking about the role of universities. We are receiving another question here about that. What's your opinion about the judges having a multidisciplinary team in court so they can carry out this analysis of empirical evidence? And this is like another question related to the same thing. So it's like a group of academics talking about that, and like an expert team inside the courts that can be helpful.
Yes, no, absolutely. I mean, I do think it's important that it's multidisciplinary. This is not just lawyers and legal scholars. I think it's important for people who are trained in a whole range of both, again, economics, those kinds of things, but especially the social sciences. And so I think about social work and psychology, family studies. Those sorts of interdisciplinary teams can come together and share their knowledge to then be able to inform judges. Now, I want to make a distinction here between individual cases and sort of broader policies. So let's just go back to this example of parental alienation syndrome, which is part of the problem with that was that the evidence was done and was, first of all, again, was just based on a few anecdotes and then was made into this syndrome that then judges were found in specific cases. And that's just not how it works, right? Again, you certainly could, in an individual case, find that one parent is thwarting the other parent from having a relationship with the child. But calling it a syndrome is not helpful, and the judge has to determine what to do in that circumstance. The way in which I think it's really helpful to have an interdisciplinary team advising judges, or really also advising legislatures when they're coming up with rules, would be around things like, what's the importance of a bond attachment between a parent and a child. So, for example, one of the things that we do with too much regularity in the United States is remove children from the care of their parents because of abuse or neglect. And obviously, abuse or neglect present real problems and threats to child development, but so too does the removal of a child. And so where the child gets taken away from a parent, and especially if they're sent to live with someone who the child's never met before, sometimes the child goes and lives with a relative, and that can be a somewhat easier transition. But still, simply the fact of being removed from a parent can be deeply traumatizing for a child. And we want to make sure that judges are trained in understanding those implications, right? Rather than just seeing, ooh, the child is facing these dangers in the home, we got to make sure we take the child out of the home. Well, that's one consideration. The other consideration is, what will be the harm to the child from being removed from the home? And we want to make sure that judges are trained in understanding both of those. And that would be a great way, a great thing for the family court system, again, as the commenter or questioner suggested, a multidisciplinary team to be able to provide that kind of education through judicial trainings.
Thank you for that. And I will talk about this syndrome. Again, there's a comment here that a person says that figure is no longer in Mexico, in the Code of Mexico. And at the same time, there are other people that talk about how in other civil codes in other states of Mexico, because this only happened in Mexico City, but there are some figures that do not refer to it as a syndrome, but they do talk about parental alienation. So I think that this problem of empirical evidence, it's still relevant in Mexico, in some states. This discussion is still current.
Yes, no, thank you for, oh, sorry, do you want to finish? Thank you for raising that, because that happened in the United States too. So now family courts they don't talk about parental alienation syndrome, they just talk about parental alienation. And it's the same, but still basing it on the same basic research. So this is, again, I really direct you to the work by Joan Meier, M-E-I-E-R, from George Washington Law School, who has written about this extensively, and it's very helpful in documenting the problems with the underlying research, and then with the courts still relying on it. So yes, I mean, this is the challenge, that when people start believing something, it's hard to get them to change their minds.
Yes, exactly. And about that same topic, we have a question here. Well, it's more like a comment or question. Which factors can help us to distinguish this young science from reliable science?
Yeah.
So I don't know if you could make a comment about that.
Sure. No, that's a great question. And again, this is why I think it is useful to have academics involved, because there are very clear standards. So let me I'll use one from the parental alienation syndrome. One of the clear standards in science, showing distinguishing junk science from reliable science, is peer review. That to have something published, it gets sent to a journal. The journal then sends it out to other people in the field who will look at the study and say, oh, you only asked 3 people about this. I'm making this up, but you only asked 3 people, or you didn't have a control group, or you didn't follow basic protocols. I mean, there are very clear protocols for and there can be somewhat field specific, but their basic overarching idea is sort of the scientific method has certain protocols that people need to follow in order for research to be reliable. And so academics can identify those, and first of all, be able to know which are the journals that have a good reputation for having very strong peer review, for only publishing, research that meets certain standards. And then they themselves can also look at, even if something that is published, to be able to say, well, this is not so useful. You didn't distinguish causation from correlation or whatever, all kinds of things. This is really what graduate school training is about training people how to do research and how to do it well and how to spot problems in other people's research. So there are very, very clear standards out there, but you need people who are trained in those standards.
Yes, totally agree with that. And to talk a little bit more about the issues that this might bring, they are asking about empirical evidence that is non-conclusive, like with the situation of vaccines. In Mexico, we had some vaccination problems with COVID for children, and it was like non-consolidated evidence. I mean, this is something quite new that was being discussed by science, or what can we do if we only have some studies on traditional families like mother, father, and children that are not taking other factors into consideration, or maybe disabilities. There are no studies about parents with disabilities. So what can we do if we are facing like a lack of elements, specifically talking about the legal context?
Yeah, no, it's a great question. And the truth is, we always want and need more evidence. Even for something that's a robust finding, it can be helpful to have more evidence. But as you say, there are lots of things about which there isn't evidence, it's incomplete evidence, or it's inconclusive evidence. And what should we do? It comes back to what I said before, is that we all need to have a healthy skepticism about empirical evidence, right? So to treat it as one data point, here's some information, but here are things that we don't know, drawing on it. So not letting it, carry too much weight. On the other hand, it's sort of, well, what do we, oftentimes you still in the legal system have to make a decision. So you've got incomplete evidence, which is, you don't necessarily want to rely on that, but what's the alternative? Relying on intuition, and there are real flaws with that as well. So I think it's just at least acknowledging the incomplete evidence, and then, maybe it's making a shorter term decision, or being open to changing it, or, to be able to say, well, this is the rule for now, but we'll have to do something different in the future. So, I mean, I don't have a great answer, because this is always a problem, right? We always need more evidence, and sometimes we need a lot more evidence from what we have. But I think we get in trouble when we take scanty evidence, if there's not enough evidence, but then we come out with this really strong policy that says, this is what we have to do, this is what the evidence shows, as opposed to saying, look, there's some evidence supporting this, it's inconclusive, we don't know what to do. Here's an interim policy while we try and figure this out a little bit more. People want very clear, clean answers and guidance, and sometimes we just don't have that. But I also think it's important for trust in institutions that we not just, we need to be candid about how some evidence is inconclusive. Most evidence is inconclusive, but some is even more than others.
Yes, it is true. This is something that we need to analyze. We have to see how objective things are, and sometimes science is objective, sometimes it isn't, sometimes it's conclusive, sometimes it isn't. So we need to assess it from these different points of view. And something else that they are asking here. In Mexico, we follow the principle of the superior interest of children welfare. So does this justify the use of empirical evidence, or which problems do you see in these principles?
Yeah, no, we do as well. That is a basic idea of, what's the best interest of the child? What's the sort of child well-being? I've written an article with Elizabeth Scott, who's a law professor at Columbia Law School, all about the ways in which we see this idea of the child well-being being the driving force behind legal regulation of children. And that is oftentimes informed by empirical evidence, and that's a real theme that we see, a real difference between regulation in the past, which was supposed to be about helping children, but wasn't really grounded in empirical evidence, and now it is. One of the places we see it the most in the United States is in the juvenile justice system, which is that we used to send children to, institutions, take them out of their homes if they committed some kind of did behavior that would be criminal if they were an adult. And so we take them out of their homes and send them off to these institutions. And we just realized that was not working at all. That child, adolescent development really shows that children have a tremendous capacity to heal, to change their behaviors, but that they need support. And that it's much more important to keep children in their homes, in their communities, not put them in institutions, give them the supports that they needed. And it really led to a really significant change in the juvenile justice system in the United States. So, sorry, I forgot where I was going with this question. What was the original question again?
Yeah, so considering this argument of the interest of children, and how can you relate it to other principles?
Right. Sorry. Thank you. Yes. So I guess what I would say is that this is still very, in the United States too, this is very much our driving goal behind family law and policy. Increasingly, we look to empirical evidence, and that's important. But again, we need some humility about what it shows, and to be able to change our change our minds as we go along.
Wonderful, thank you. I'm still checking if we have more questions, but I guess that we have concluded all the questions, and I just want to say that people are sending like a lot of messages from Texas, from Mexico, from everywhere. So I think that this session was quite interesting for everyone. We're living this session with a lot of reflections and things that we can apply in the Mexican context. And once again, we want to thank you for your presentation, sharing all of this with us. I don't know if you would like to say something to wrap up before we leave.
I just want to say it's such a privilege for me to be able to talk to you. I really think, legal systems all around the world are really struggling with these issues as well. One of my favorite things is comparative family law, because I think we all have so much to learn from each other. And so I'm just very grateful to have had the opportunity to come and share my research. And I really look forward to learning more about what you are doing and then plan to do in the future in Mexico. So thank you for having me.
Thank you very much, and hopefully this conversation can continue in the future. Thank you, and thank you to all of those that were here, and also for the interpreter. And thank you very much, and have a good day.
Thank you.
Thank you, Claire. We finalized the broadcast, and we are about to close the session. And once again, I just wanted to thank you. It was really interesting, and thank you once again, and see you soon.
Thank you for having me. I appreciate it. Goodbye. Have a good day.